We've got a major development in one of the most important legal fights over rifle and magazine bans. The Trump administration has officially weighed in on the legal battle against Illinois' restrictions on certain firearms and standard capacity magazines, claiming these bans violate the Constitution. Meanwhile, the state of Illinois is trying to push back, but they're also playing for time. So let's break down where things currently stand. Before we dive deeper, if you want to support this channel without spending a dime, just tap that subscribe button and give this video a thumbs up. That simple gesture really helps us reach more freedom-loving Americans. And hey, if you drop a supportive comment down below, that tells the algorithm to push this pro-Second Amendment content out to more people like you. So here's the deal. Illinois' so-called assault weapons and magazine ban is being challenged hard in federal court. We recently discussed how the Trump administration submitted an amicus brief backing the plaintiffs in this case. In that brief, they argued that Illinois' restrictions on semi-automatic rifles, like the AR-15 and commonly owned magazines, clearly infringe on our Second Amendment rights. At the moment, the case is back in front of the Seventh Circuit Court of Appeals. The state is pushing to overturn a pro-Second Amendment ruling handed down by Judge McGlynn at the district level. His decision invalidated the Protect Illinois Communities Act, also known as PICA, on constitutional grounds. But now, Illinois wants that decision thrown out. Fortunately, the Trump administration stepped in again, urging the appellate court to let Judge McGlynn's ruling stand. They argued that banning widely owned rifles and standard capacity magazines runs directly against the Second Amendment. Now, in response, Illinois is asking for more time, specifically an extra 30 days to prepare their counterarguments. They're trying to delay their response brief so they can address not only the plaintiffs' claims, but also the amicus briefs filed by the Trump administration and other pro-Second Amendment groups. You might remember that earlier in this case, there were several lawsuits filed in federal district courts. Those judges issued temporary injunctions blocking enforcement of PICA, but the state of Illinois took those injunctions up to the Seventh Circuit, which overruled them and reinstated the ban. That led several plaintiffs to file emergency appeals directly with the Supreme Court. The High Court declined to hear the case on an emergency basis, but Justice Clarence Thomas did issue a statement. He made it clear that if the Seventh Circuit lets Illinois continue banning the most commonly owned civilian rifle in America, the court should step in once a final ruling is made. Thomas warned that the Second Amendment cannot be treated as a second-class right. While all this was unfolding, Judge McGlynn decided to fast-track these challenges toward a final decision on the merits. And when the time came, he once again declared PICA unconstitutional and ruled that it must be struck down in full. Of course, Illinois didn't back down. They appealed that ruling yet again, asking the Seventh Circuit to overturn it. Their argument? That AR-style rifles, detachable magazines, and related accessories are weapons of war and supposedly not covered by the Second Amendment. These are the same tired claims we've seen from other anti-gun states. But Illinois is sticking to the script. Now, it's back in the hands of the notoriously anti-gun Seventh Circuit, who has already shown where they stand during the preliminary injunction phase. But with mounting pressure and strong legal backing from the Trump administration and other pro-Second Amendment voices, the fight is far from over. Now here's where things really heat up, because the Trump administration, through the Department of Justice, just jumped into the legal fight and threw its full weight behind the challenge to the Protect Illinois Communities Act, also known as PICA. In a freshly filed amicus curiae brief, the federal government made a strong case that this law is flat out unconstitutional. In that brief, they reference a landmark ruling handed down by the Supreme Court 3 years ago, a decision meant to put an end to states treating the Second Amendment like some second-rate privilege instead of a full-fledged constitutional right. Unfortunately, Illinois didn't get the memo. Not long after that ruling, the state passed one of the most aggressive so-called assault weapon bans in the country, outlawing some of the most widely owned rifles and standard capacity magazines used by law-abiding citizens across America. According to the Trump administration's argument, Illinois' actions fly directly in the face of the Supreme Court's clear instruction. The government cannot outlaw firearms that are commonly possessed by responsible Americans for legal use. Previously, when a lower court issued a preliminary injunction to halt PICA, the Seventh Circuit reversed it, saying the law was likely constitutional, but even then, the appeals court admitted that their decision was a first look, not the final word. Now, the Trump administration is urging the court to reverse its earlier position and support the district judge's injunction. They laid out 3 core reasons for this change in direction. First, they argue that the earlier decision referred to as B's got some fundamental Second Amendment analysis wrong, even based on the legal precedent available at that time. Second, several justices on the Supreme Court have recently signaled that they don't agree with B's or similar decisions from other lower courts, and that the High Court is likely to step in soon to correct these misinterpretations. Third, after the B's decision, the lower court conducted a thorough multi-day trial, took in significant factual evidence, and concluded that banning semi-automatic firearms and accessories commonly used by law-abiding people for lawful reasons violates the Second Amendment. In short, the Trump administration is saying the Seventh Circuit needs to course correct and allow the injunction to stand. It's a powerful, well-supported argument from the federal level in favor of gun rights. Digging deeper into the brief, the government emphasizes a critical point. Under the plain language of the Second Amendment, the question is whether these banned semi-automatic rifles qualify as arms. And their answer is yes, absolutely. Rifles like the AR-15 are clearly considered arms under the Constitution, and the government now explicitly says as much. They even point to recent Supreme Court rulings, including one involving Smith and Wesson under the Protection of Lawful Commerce in Arms Act, where justices like Clarence Thomas and Elena Kagan recognize that rifles such as the AR-15 are in common use for lawful activities like self-defense and sport shooting. Furthermore, the Trump administration calls out the Seventh Circuit's flawed logic in applying a military-style weapon test, arguing that it's inconsistent with what the Supreme Court laid out in the Bruin decision and similar cases. They explain that neither the wording of the Second Amendment nor the historical record supports that kind of framework. In fact, they go a step further, explaining that, historically, citizens were expected to bring their own firearms when serving in the militia. Those same rifles used for self-defense at home were also intended to be used, if needed, in defense of the nation. So suggesting that so-called militaristic weapons are not protected by the Second Amendment is not only wrong, it directly contradicts the original purpose and spirit of that constitutional right. When it comes to magazines, The Trump administration is also pushing back hard, making it clear that the Protect Illinois Communities Act (PICA) not only violates the Second Amendment by targeting rifles, but also by restricting standard capacity magazines. In their brief, they explained that the Second Amendment doesn't just protect the right to own firearms, it also shields essential components tied to that right. They point out that previous rulings have recognized the right to self-defense includes certain critical accessories. So even if items like magazines or suppressors don't technically fall under the keeping of arms, they're still a core part of exercising that constitutional freedom. The Trump administration's position is that commonly owned attachments like magazines, suppressors, and other add-ons that Americans use every day fall under the umbrella of protected arms. That's the heart of what the federal government is arguing here. They are taking a firm position. Standard capacity magazines, suppressors, and other widely used firearm components are part of the Second Amendment. Now, there's a lot more legal detail in that filing, but that gives you a good look at just how aggressively the Trump administration is pushing back against this ban. Meanwhile, the state of Illinois is trying to pump the brakes. They've now asked for an additional 30 days to submit their reply brief. Their reasoning: they say they need extra time to deal with all the points raised not just by the plaintiffs in the case, but also from the Trump administration and several other amicus briefs that were filed in support of the challenge. In their motion for an extension, Illinois officials said they're facing a mountain of paperwork, over 200 pages of arguments split between 4 core briefs and 4 amicus briefs. They're claiming this is way beyond what you'd normally see in a response filing, and they need more time to handle it all. In reality, though, this looks like yet another delay tactic. They're trying to buy time because they know they've got a serious fight on their hands, especially now that the Trump administration is involved. Still, no matter how long Illinois tries to stall, they're going to have to eventually face every single argument made against this unconstitutional law. And the spotlight is now fully on the Seventh Circuit. Now, if you're wondering what I think will happen, I'll be honest. Based on their track record, I wouldn't hold my breath. The Seventh Circuit has not exactly been friendly toward the Second Amendment in recent years. When they ruled on the earlier injunction, they didn't take the Constitution or the Supreme Court's guidance very seriously. And I wouldn't be surprised if they double down and uphold the ban once again. But here's the thing. Justice Kavanaugh already warned that time is running out for lower courts that refuse to follow the Second Amendment framework laid out in Bruin. He hinted that in the near future, maybe as soon as the next term, the Supreme Court could finally address these types of bans head-on. In fact, when the High Court declined emergency review of the Snope case and Ocean State Tactical, they specifically referenced this Illinois challenge. So clearly, this one's on their radar. If the Seventh Circuit ignores the warning signs and sticks with its anti-gun stance, this could easily be the case that makes its way up the ladder. And if that happens, the consequences could be huge. So to sum it all up, Illinois is dragging its feet and asking for more time, trying to deal with the heavy fire brought in by the Trump administration. But the fight's not over, not by a long shot. As this case moves forward, I'll be right here to keep you informed. Thanks for watching, folks. As always, don't forget to hit that like button, leave a comment to boost the signal, and subscribe if you haven't already. And remember, this country was built by patriots, and it's going to be preserved by patriots who stand up and defend freedom every single day.